Hi, welcome back to HOA Hell. I'm your host, Michael Kushner, and with me today, as always, is Senior Associate from my law firm, MBK Chapman, Sam Kill. Hi, Sam.
Hello, Mike. Glad to be with you.
As always, I'm glad you're here.
Thanks.
Today, we're going to talk about something that we have seen. It's something that occurs relatively regularly, especially because we are dealing with, every few years in California, we have drought conditions. Mm-hmm. And it's when the drought conditions are especially prevalent that this issue pops up the most. So during seasons of plentiful water, it's not as common. We don't see it as much. But then when a drought's in effect or we're having a particularly dry season, or let's say there's a lot of fires or whatever, this seems to come up more.
Right.
So it's kind of a off again, on again type deal. But it relates to HOA conflicts with homeowners involving drought-resistant landscaping. And the HOAs, we see a lot of HOAs go on both sides of the spectrum. Either they're attempting to enforce the law where they don't have the power to do it, or they're attempting to prevent people from complying with the law or complying with environmentally conscious standards. And so we're going to talk about the push and pull today, okay? So specifically, drought-resistant landscaping is going to be kind of our topic today, and what the HOAs can and can't do. So, and kind of the precursor for this is that a lot of HOAs act like when they're given architectural control over standards and aesthetics, they act like they can control every blade of grass.
Right.
And that's not true.
Yeah.
In no way does an HOA have authority to do that. And so some HOAs go too far, and some HOAs go the other way, okay? So we're going to discuss what the law actually allows the HOA to do and where that power comes from. And then we're going to talk about real scenarios, real advice, or real examples of where we see this and what you can look for and how to deal with it if it happens to you. So I think we'll have a little bit of everything here. My goal here in this episode is to provide California HOA members with clarity, okay, on what the law is and on what their HOAs can do based on what the law says and what the governing documents say. So let's start with the basics. Let's start with what the law actually says. The statute that we're going to talk about today, in particular, is with respect to drought-resistant landscaping, is Civil Code 4735. Now, that section of the law was passed during a time of serious drought in California, and it does something very specific. At least its intent was. And then it was amended again, by the way, in 2015, right before Governor Brown issued statewide proclamations on limiting, like, for example, you can only water your grass on this day or that day, that sort of thing.
That's right.
But its specific goal was to prevent HOAs from banning drought-tolerant landscaping, because that's what was happening at that time a lot. And we see that now. So this means an HOA can't stop a person under 4735 from planting native species, using mulch or bark, which is one of the ways that, or those white rocks, a lot of the stonework, replacing turf with artificial grass. A lot of HOAs try to prevent that because it doesn't always look like the real thing.
Right.
It really depends on how much you want to spend. And also, some HOAs try to pass rules mandating a reduction in water footprints.
Yeah, surprisingly. I mean, that's a big misconception too.
Well, before I want to ask you a specific question.
Okay.
But before I ask you that, let me just get a little bit more out. It's when the HOA steps in and tries to either mandate or limit what somebody can do that we run into problems. So it's both ways. Okay, that's when things go sideways. All right, and many homeowners mistakenly believe that the law allows HOAs to require drought-tolerant landscaping, and it doesn't.
Right.
So 4735 was put into place to protect a homeowner's right to plant drought-resistant landscaping, but it was never intended as a mandate. And I think you were going to comment on that.
And that's exactly it. I mean, that distinction between those two, it's a huge misconception, and it's a critical one, I must say. This is where far too many California HOAs are confused and basically interpreted one way or the other, running afoul of Civil Code 4735. And that largely stems from either confused or misguided management companies or you're dealing with board members who use the HOA as an agent of either social or political change, who are environmentally oriented.
Right. So basically, the long and the short of it is the law was put into place to protect your right as a homeowner to plant drought-resistant succulents, cactus, some of that. Think Southwest. Think kind of Southwest landscaping type deal,
Right.
okay? The low impact, low water impact planting. It was to prevent HOAs from banning it on aesthetics. If everybody else has lush green lawns and you want to plant artificial turf and cactus and succulents and it looks different from everybody else, the HOA is prevented from 4735 from saying no based on aesthetics. Now, if there's a safety issue or what you're planting is causing damage to somebody else, they can put limitations. Of course they can. But we're talking from an aesthetic. This doesn't match our aesthetic. Right. That's what the statute was for. Some HOAs interpreted that statute as saying, well, now we can mandate. You know, even though you might have spent $200,000 or $100,000 or $300,000 landscaping, and we approved all that in the past, we want you to tear it out and put in water-resistant plantings.
No, can't do.
Can't do that unless the HOA specifically is given itself that authority, either by rules or the CCNRs has that authority in their governing documents. They can't do that. Okay, so I agree with you. That is a big issue. Is you get confused HOAs that went much further, and we're going to talk about that in specifically a little bit more. I guess right now we can go into it. Okay,
let's do it.
So I call that common area or common HOA overreach. Okay,
Agreed.
And the overreach goes in two ways: either trying to prevent or to mandate. So we're going to talk about both. Okay, so let's talk about how HOAs get it wrong, and they get it wrong in a lot of ways. So the best way to kind of walk you through this is to just give you examples from real cases that we've had.
Okay.
Because that's the best teacher, is here's how it translates into the real world. Okay. So we see a variety of fact patterns that come in, and we've seen each of these more than once. And so these are ones that we could say are kind of the more common patterns that we see. Okay. So first one I have in my notes here that I want to talk about was, we've had boards tell homeowners that they're required to remove real grass, water heavy grass, and install decomposed granite. Okay. Even when their existing lawn or landscaping had been previously approved and installed, mind you, at great expense. For those of you who've ever installed grass, it's not cheap. You're not only paying for the actual sod, but you're paying for the installation with your landscaper. And depending on how big your lawn is, that could be very expensive. Okay. Never mind all the flowers and bushes and other things that require watering. Okay. Especially in the summer.
Right.
So we've seen boards do that. Okay. Probably not going to work, but we'll talk about that. Okay. We've seen HOAs threaten fines for people who water their front yards too much. Okay.
Yeah, I've seen that a few times. Yeah.
Even if the landscaping that's been installed that requires the watering was previously approved, and without the watering, the plants would turn brown and foul and die, and they probably get sanctioned for that as well, because that's also one of the examples. Okay. We've seen HOAs pass rules.
Right.
Okay. And we know that rules are much easier to get by than a CCNR change, which requires a vote.
Yep.
Okay. Banning artificial turf entirely, even though the statute is crystal clear. 4735 says that's illegal. Can't do it. End of story. It is very, very, very clear.
I recently had one of those, by the way.
Right.
Yeah.
And I'm aware of that. Now, and by the way, that was a ban not based on maintenance or safety, but on aesthetic.
Right.
Okay. Can't do it. Okay. We've seen boards refuse to consider landscaping modification requests unless they conform to unstated water-wise policies. In other words, we want your plants to be more environmentally conscious. Can't do that unless it fits into one of the specific exceptions we talk about in a few minutes. Okay. We've seen HOAs fine homeowners for violating either citywide or statewide water conservation mandates. So, for example, in 2015, when Governor Brown issued those mandatory water cuts that went into effect for both residential and commercial water use, and we're not talking about use of recycled water, that's covered under the statute as well, but most homeowners don't actually have access to their own recycled water conservation systems. So I'm leaving that out on purpose. But when Governor Brown issued, and I'm just going to make this part up because I don't remember what he did back in April of 2015, but let's say he said, if you live in these communities, and there was like a color code for the state, you can water on Monday, Wednesdays, and then if you're in this color, you can do Tuesdays and Thursdays, and no watering on this date, something like that. And HOAs were fining homeowners for watering on days they weren't supposed to be watering. And finally, we've seen boards fine homeowners for allowing their lawns to turn brown or die because they weren't watering, because they were following either a citywide or statewide water conservation mandate. So those last two I want to focus on for a few minutes because those are the flip side of each other, okay?
Yeah.
So in each of those cases where the board fined you for allowing your stuff to die or the board fined you for not complying with a state or city mandate, flip side, those are each completely opposite, right? Both cases, the HOA, in the cases we've handled that had those fact patterns, completely overstepped their legal bounds.
Absolutely.
Okay? So let's talk about those two for a minute. Just remember, so in Civil Code 4735 existed in 2015. It was already there. But in January of that year, some revisions went into effect. January 1st of 2015, some revisions to 4735 went into effect. And among the revisions that went into effect was what is there now, which is that HOA can't punish somebody for allowing their stuff to die, like for turning brown, okay? In other words, if a member of the HOA is following a mandated water conservation order from either the city or the state, and as a result of that following the mandate, the plants in effect started to die or turn brown, which is ugly, it is blighty, it isn't good. It prevented the HOA from fining you for that if that's what was happening. Okay. And then, of course, 3 months later, January, February, March, 3 months later, after some of these provisions went into effect, that's when the governor issued that proclamation that limited when you could water. Okay. And for those of you who've listened to our podcast before, you know that there's another statute that we always cite. And it's that rulemaking statute. It's the statute that allows HOAs to promulgate rules. Now, the vast majority of CCNRs, usually not in the articles or the bylaws, but it could be those two, but it's usually the CCNRs, vast majority, give HOAs the authority to pass rules, okay? Well, Civil Code 4350, which is the statute we talk about all the time, is the statute says, okay, assuming you have rulemaking authority, what does that mean, right? And that's the statute that says that rules have to be in writing. They can't conflict with a higher document like the CCNRs or the articles or the bylaws. Right. And they can't conflict with state law or federal law, if that was the case, or even municipal law. Okay.
Operative law,
Right. And lastly, and I consider it to be most importantly, it has to be reasonable.
Yep.
And we talked about that objective, reasonable standard. Okay. So that's 4350. So in addition to complying with 4735, rules have to also comply with the rule statute, which is 4350, that says they got to be in writing, they can't conflict with a higher law, they can't conflict with a higher governing document, and they have to be reasonable, okay? Oh, and it goes without saying they have to be adopted properly, pursuant to whatever the requirements are, 28-day notice period, all that stuff. Okay, so even if a board's policy sounds reasonable, and for example, we want to support a state-mandated reduction in water use. We, as an HOA, agree with the governor. We want to support that. That's reasonable, objectively reasonable, okay? Doesn't mean that they have the power or authority if that authority isn't already in the CCNRs or their rules, okay? In other words, if there's nothing in the CCNRs or the rules that say that an HOA has the power to mandate that you plant water-resistant or drought-resistant plants or landscaping, then if an order comes down from the government, they can't be an enforcer, or a policeman of state policy.
They're not an extension of the state.
They're not.
No.
Now, here's what some HOAs did. They proposed a new rule, and they went through the process of the 28-day rule thing, and they said, and they adopted, as a rule in their HOA, they adopted the state mandate. At that point, if it went through the 28-day process, there was no successful veto by the homeowners under the statute, then at that point, if somebody was watering on a day they weren't supposed to be watering, at that point, the HOA would be well within its powers and rights to enforce, because they've adopted properly into their own rules and regulations the state mandate.
Doesn't run afoul of the operative law, and it's arguably reasonable because there's a nexus to public
It's
policy.
reasonable because it's what
drought.
it is public policy.
Exactly.
I mean, the government has said, the state government at that point has said, this is reasonable, otherwise it'd being challenged in court, right?
Yeah.
So there's nothing preventing an HOA from adopting a rule, as long as they do it legally, that mirrors the mandate. At that point, they now have power. Now, does that mean they can have you rip out your $250,000 landscaping? No, that would not be reasonable. But could they require, okay, all future landscaping? Sure. Or could they say, we're not going to require any landscaping at this point, but we are going to police to make sure you're not watering on Thursdays if you're only supposed to be doing Monday, Wednesdays. So if we see you do that, we can fine you. If they adopt that mandate and they do it properly, that's okay. But most HOAs don't do that. And if they haven't done that, they can't police for the state. That's the bottom line. So unless your governing documents, which includes those rules, allows the HOA to mandate water reduction policies, and what they're trying to do is reasonable, they can't do it.
Right.
And they can never mandate the opposite, which is, we're going to fine you because you're allowing your grass to die because you're only watering twice a week and there's in effect an order. Now, as of today, we're in July of 2025. There's no mandate at all on the state. Okay, that was lifted a long time ago. So that's not relevant right now, but it could be relevant next year or the year after. We never know what's going to happen and what the governor might do at that point. But right now, we're not under any such order. Right. But if we were, unless the governing document said otherwise, they couldn't do a thing about it. And they can never violate that statute, okay?
Right.
So, based on kind of what we've talked about, a landscaping rule is going to be deemed reasonable if it's merely just mirroring a mandated law, either by the city or the state, that isn't being challenged, right, based on reasonableness. It's probably going to be deemed reasonable for what Sam said, public policy, right? But there are going to be scenarios where even if they properly adopted the rule, and even if they are attempting to impose a rule that's been properly adopted, it's probably not going to pass that reasonableness test. So let me give you a couple of those, because that's something to look out for. One, if what they're trying to order you to do substantially or imposes a substantial monetary cost on the homeowners without a truly equally compelling justification.
Yeah.
Okay. I'll give you an example of a compelling justification. 2 years of drought has caused severe fire dangers for your particular area. You're already in a high fire zone, and it's excessively dry. And they now have been told under new, improved, fire marshal policies that they need to cut an extra X amount of yards, and they're having everybody cut back from their property lines, let's say, to provide additional buffer based on recommendations by their local fire marshal. If that ends up costing 15 or 20 grand to do that, that's probably going to be ruled enforceable.
Agreed.
Because the cost of fires destroying houses is so much more compelling that individual cost isn't going to overrule. Okay?
Yeah.
So, but generally speaking, if it and we talked about this substantial cost, they want you to rip out hundreds of thousands of dollars in landscaping that's already been approved just because of because we believe in the public policy of lower water use. That's not going to be reasonable.
Too extreme. Yeah.
And it's not compelling justification.
Yeah.
Okay. Another one is what we always talk about, selective enforcement. They're inconsistent application. They're going after you and maybe a couple others, but not this person, that person, or that person. No. It's either they do it across the board or they don't do it at all. They do not get to select specific people to go after. They just can't do that. Okay. So that's always going to be problematic, and it'll never be reasonable. It conflicts with a higher ranking document or a higher ranking authority.
Right.
So what they are trying to impose, even if it's in the governing documents, conflicts with a municipal order or rule or law or a state. Okay, city will always trump HOA. State will always trump city.
Yep.
Federal always trumps both, unless it specifically says it doesn't. Okay? And finally, it was adopted without proper notice or without proper procedure.
Right.
But that goes without saying. It's dead in the water if
Defects,
it does that.
yeah.
Okay? So the takeaway here is that HOAs do not have independent police powers to enforce state laws or municipal laws. Okay? Unless their CCNRs or operating rules give them specific authority to do X, Y, or Z with respect to your landscaping, then they can't do X, Y, or Z. And even if they have that specific power, it can't run afoul of, for example, 4735.
Right.
So if they say, well, notwithstanding state law mandates on watering, if your grass dies, we're going to fine you, they can't do that, no matter what. Okay? So that's basically the law. Now, and that's kind of sometimes where you can tell when the HOA's gone too far. Those are the generals. We'll get more specific in a couple minutes, though. Now, we see situations sometimes when the CCNRs or governing documents actually do contain limitations. Okay, I know you've seen that. Let's talk about a couple of those, just to get some examples, and we're going to talk about some scenarios. And this is where I want to hear from Sam a little bit. So some associations, especially the newer ones, and when I say new, 10 years? Yeah, HOAs formed in the last 10 years or so. Doesn't mean an older HOA might not have redone their documents in the last 10 years, in which case it might include this. But we're seeing these with newer CCNRs, okay, relatively. And they incorporate water conservation standards, at least to some degree, directly within their governing documents. So, for example, after 2015, which was 10 years ago, some HOA CCNRs, right, from the get-go, are going to remember, hey, this thing in 2015, so let's put some of that in there.
Yeah.
So you see water conservation, you'll almost never see it 30 years ago.
Right.
But you're going to see it in the last 10 years, right? That's a fair way to say that?
Absolutely. Right. And it's generally in response to the recently evolving public policy, running into issues with insurance, high fire zones. I see this a lot with the Inland Empire.
Right, where it's very hot.
It's very hot. You see that quite a bit, and you're right, exactly, in terms of the recency of it, past 10 years or so.
Right,
and that aligns with a 2015 time mark with Governor Brown's efforts. Yeah.
And I said this before, some of these CCNRs, and this is more rare, so I'm not going to say we see this a lot. I've seen it maybe once or twice that I can think of specifically, where we actually had CCNRs that we saw that were passed or that were created in the last 10 years, so since 2015, and yet they ban artificial turf.
Yeah.
That's dead in the water.
Right.
I don't understand how it even got there, because that should have been vetted by the attorney that wrote the CCNRs, which leads me to believe maybe the developer or somebody that drafted the CCNRs went and got some samples of their own and did their own. I can't imagine an attorney that knows how to draft CCNRs that would include something that so blatantly violates a very crystal clear statute, 4735.
Yeah. Okay.
So I have to assume that those CCNRs that I saw that I'm thinking of, the couple of times I'm thinking of it, it couldn't have been written by a lawyer. I can't believe that, because the city or state code, in this case state, okay, part of the Davis-Sterling Act, will always trump CCNRs. But we also see your CCNRs, we've seen more recent CCNRs require well-maintained landscaping.
Yeah.
But it doesn't specify what that means.
Exactly.
Okay? That doesn't mean they have free reign to impose broad restrictions.
No.
If all they have in there is well-maintained, that's not going to be good enough. What does well-maintained mean? Okay?
Yeah.
So let's talk about some practical scenarios.
Okay.
Okay? Tell me if you've seen a case like this, Dan. Your HOA says that your green lawn is wasteful. Okay? You have a big lawn, and it's beautiful, just gorgeous, beautiful green, soft, yummy to sit on. Okay? It's wasteful, and they want you to convert to artificial turf. They want you to install artificial turf.
I've absolutely
What's
seen
your
it.
response?
Can't make you do it.
Unless
the governing documents, and specifically the CCNRs, contain some kind of a basis for that.
Or
Yeah.
outright say no natural grass.
Correct. I mean, if it's that type of a community, kind of forward-looking community, then yeah, okay.
Now I've seen CCNRs like that in Palm Springs.
Yeah.
Okay, Palm Springs, for those of you, I probably shouldn't have to explain it, but maybe in Northern California, if you're not as familiar, Palm Springs is really hot. It's the desert.
Oh, yeah.
So during the summer, you're getting in excess of 100 degrees almost the whole summer. I mean, it's really, really uncomfortable. Okay, I personally couldn't stand that. I couldn't live there. I would die. But people play golf there. And those golf courses, by the way, are beautiful, and they're all green. But they use recycled water. There's a commercial thing. They use recycled water. But we've seen CCNRs in Palm Springs that just mandate artificial turf from the get-go.
Yeah.
Okay? That's enforceable. That's legal. People, you could choose not to buy into that. If that's not something you want, don't buy into the community.
I've even seen percentages where they say like this percentage of rocks, this percentage of artificial grass. Which
I haven't seen that. I've never seen
Palm Springs, by the way. Yeah.
Oh, okay. In the CCNRs?
CCNRs.
Interesting. I have seen that in the rules, architectural guidelines. I've never seen it.
Well, they revised and amended the CCNRs and then got into that.
Okay.
Yeah.
All right. That's good. So here's what I would do if your HOA tries to do that. I would say, first of all, show me where in our governing documents you have the authority to do that.
Yeah.
Show me the CCNRs or the rules. Sam mentioned CCNRs. It could be in the rules, okay? But show me that, cite the section that mandates me to have artificial turf. If they can present that and it was properly done, then you're going to be beholden to that unless you spent a good deal of money doing it the right way and were approved, and this came after the fact.
Yeah.
So it might not apply, even though the statute doesn't have a retroactive clause. Under reasonableness standards, it might be unreasonable to make all homeowners rip out what they have, but they could certainly require new landscaping approval to be conditioned on it being artificial. Okay? That is absolutely doable. If there is no such authority in those governing documents, either CCNRs or rules, tell them, you can't do that. Sorry. See ya.
Right.
I'm not going to do it. Have a nice day. Tell them no. Okay? Here's another one. You sought permission to replace your lawn with artificial turf. So it's the opposite, okay? You want to include bark mulch. You want to plant a bunch of succulents. Those are those really cool-looking plants that never have to be watered. Okay, so if you kill plants for a living because you're just not good with them, these are really hardy.
Yeah.
You're probably okay. I like to say, think Southwest. Think Southwest aesthetic, okay? Now, let's say your HOA denies your request, says your landscaping just doesn't conform to the neighborhood aesthetic. Sam?
Can't do it. It runs afoul of, public policy, but specifically 4735.
Okay.
Yeah.
Let's say the CCNRs say that they have the authority to deny you based on the aesthetics. What about that? They went to the trouble of passing CCNRs.
I would say still no.
Yeah.
And here's why. Because although there's, I guess, the adequate basis pursuant to the governing documents, it is trumped by operative law.
Yeah. It's a hard no.
Yeah.
The statute specifically says that HOAs cannot ban or pass a rule that has the effect of banning.
Yeah.
Okay? Because they try to do backdoor stuff, and the statute tried to foresee that. Any of your attempts as homeowners to plant water-conserving, drought-resistant Southwest plants.
Yeah.
If you want succulents, if you want cactus, if you want whatever those little teeny palm things look like that have the pricklies, you can plant them.
Those baby palm things, yeah.
They cannot stop you, even if they properly pass something in the rules or they amended the CCNRs properly, because it doesn't trump state or, in this case, maybe municipal law. Right. Both. In this case, it's probably both.
Yeah.
Okay? Scenario 3, HOA is fining you for not watering your plants or allowing your lawn or plants to die because it looks like hell. Okay? But you have been following an in effect state mandated conservation request, order, or suggestion.
Right. Your HOA cannot do that. Again, running afoul of state law or the local mandate.
Right. In this case, it's 4735C. That was one of the sections that was added in 2015 in January, went into effect January 1st, that specifically, because that had become a problem, and said, okay, you guys can't do that anymore. If the state, even if it's not a mandate, if it's a recommendation, hey guys, please lower your water usage by 25% if you can. It'd be really helpful. And so homeowners start doing that and their plants die. And then the HOA goes to find them. 4735C said, nope, can't do it.
Yeah.
Can't do it. Okay? Last scenario, HOA is fining you for watering during a restriction, during a mandated city or state restriction, even though you're following, or even though you are admittedly ignoring that state mandated restriction. So the governor orders you to water only on Tuesdays and Thursdays, and you decide, you know what? I don't like dead grass. I'm going to water Monday, Wednesday, Friday, and Saturday.
HOA cannot do that. They're not an extension of the state. They don't have policing power to enforce state or any other ordinance.
I would agree with you unless
the governing documents, specifically the CCNRs, contain that. Yeah.
or the rules, not just CCNRs. There's a court case on this. There's at least one court case.
Well, I guess it would be reasonable. So under the rules too. Right. Yeah.
So the rule said if they passed a rule that adopts the mandate, then it's enforceable. What they can't do is make it enforceable retroactively and require you to rip stuff out, because that's when it'll run afoul. Even the state thing would run afoul of reasonableness.
Right.
Because that's when people can take even the state to court.
It could be draconian. It could be extreme. Yeah.
I mean, even if a state were to pass that law, I guarantee there's going to be a legal fight for that.
Yeah.
People are going to sue because that's not reasonable.
Right.
Okay. So let's look at board tactics. Your HOA is trying to force you to make these different changes or prevent you from making changes according to the 4 scenarios that we gave you. Okay. And you think it's a violation of the law. Here's what you should do. And this is going to be your key to dealing with these things. First thing I would recommend that you all do is request clarification. Okay. Ask the board to cite, and we said this a minute ago, ask the board to cite the specific provision in the governing documents that authorizes them to do whatever it is they're telling you to do or not to do.
What's the basis? Yeah.
Yeah. Tell me and they have to be specific.
Yeah.
Okay. Number 2, request, if that doesn't work and you feel it's useful, request
IDR, internal dispute resolution. Yeah.
Right.
Mm-hmm.
Remember, and we've talked about this in other podcasts, when a homeowner makes a written request for IDR, internal dispute resolution, which is just, I demand that the board make one or more directors available to sit down and talk to me about why I'm annoyed.
Mm-hmm.
The board is required by law to engage in the IDR. They cannot charge 1 penny for it.
Yeah.
They cannot charge to have their attorney there. They cannot charge you for the director's time. They can't do any of that. It's free. And it's mandatory if you want it. It is not mandatory if the HOA insists on it. Even if their papers say it's required, it's not. Only if you demand it is it required, which is why I prefaced this by saying, if you think it's worth your time, it is under no circumstances by any law or any governing document ever required of you, but if you want it, they are required to engage. Okay? So if you think it's worth it, demand ADR or IDR. Internal dispute resolution. Mm-hmm. 3, write a letter or an email. I recommend an email because you have kind of proof of delivery. But if you're going to do a letter, make sure it's proof of delivery, signature upon receipt, that sort of thing. Write an email. You can write to the board or the management company or both. And that letter or email needs to explain why their mandate or order or denial, whatever the case is in your case, is illegal, in your opinion, why it violates either 4350 or 4735, why or why the governing documents do or don't say what they have said they've said, or even just challenging what they're doing because let's say they've refused to engage. Let's say you previously asked them to please provide me with your authority in the governing documents and they didn't do that. You follow up, but it's in writing. Everything's in writing. Yep. And of course, as Sam always likes to remind you, be professional, leave your emotions at the table, just be factual. Don't make attacks. Don't this person said and just the facts.
Treat the correspondence as if a judge or someone down the line will see it.
Assume for sure that a judge or jury is going to read your email in open court. And remember, you want them to like you, okay? And then, of course, as part of that last one, I guess, is document everything.
100%.
Keep a log. Keep all your emails in a certain place. Have everything easily available.
Photos. Yeah.
Yeah, agreed.
That's huge, yeah.
Okay. And depending on the situation, it'd either be photos of other people's places or photos of yours, depending on what the HOA is acting. This is really not a complex subject, okay? And it's also not, it shouldn't be too controversial, but it is because when you're dealing with a lot of HOAs, this is where power is exerted and people like their power. And so this is where we see this. Or people with good intentions allow those intentions to run roughshod over people's freedoms.
Yeah.
Okay?
Exactly, yeah.
And
And some are legitimately confused. Yeah.
Or dumb.
Yeah.
Or both. Exactly. Okay? The bottom line and the takeaway from this episode is we've seen too many HOAs try to impose unnecessary, expensive, illegal, overbroad demands on homeowners. And in this case, when it comes to the water resistant or drought resistant landscaping, we have a statute that's right on point that really is very good at or should be good at settling any controversy here.
Yeah.
Either governing documents are going to be reasonable and adopt state mandates, or they won't. And if they don't, then they can't adopt themselves additional powers. It's not how it works. Okay? So if your board's trying to force you to make changes to your landscaping that penalize previously approved choices or penalize you from trying to make environmentally conscious choices, you need to push back in case, especially if these rules and regulations are based on aesthetic standards. Okay? Because unless they specifically have authority and it passes muster based on what we've talked about today, it's almost certainly going to be illegal. Now, if none of that works, if you've attempted to deal with this informally and rationally, and your HOA or management company has taken a hardline position and you believe that they're just wrong based on what we've talked about today, that's when you come to us at MBK Chapman and we will hold your HOA accountable. This has been another episode of HOA Hell. If you like this episode or found it helpful, please hit the like button. And if you haven't already done so, please subscribe to the channel, HOA Hell. As always, if you have comments, we love to hear from our listeners. You want to pose any questions, maybe we can answer them online or even on the air. Until next time, have a wonderful day.